I assume you have already reserved your time for rebuttal.
I will reserve 5 minutes, Your Honor.
5 minutes, thank you.
Thank you. Good afternoon, Your Honors. My name is Jeffrey Miller. I'm an attorney from the Bradley County Bar, and I represent Toney Mitchell, who was the defendant appellant in a divorce case in the Bradley County Chancery Court in Cleveland, Tennessee. This case was sort of typical, a marriage of somewhat long duration, 3 children involved, and the parties, the wife filed for divorce, and then the father or my client filed an answer and a counter complaint for divorce.
How long was the marriage?
Your Honor, I don't have that. I don't have that memorized, but I think it's. They met on a Christian website where the plaintiff lived in the Philippines, and through a courtship online and subsequent bringing her to the United States, they got married, and they subsequently had 3 children. The children were approximately 16, 12, and 5 or 6 at the time of the divorce hearing. Again, typical, where the parties are asking the court to see whether or not a divorce should be granted, and then to divide the marital property, and then also to establish a parenting plan between the parties. I'm here seeking, on behalf of Mr. Mitchell, seeking reversal of the trial court's opinion in 4 different areas. The first area, quite shockingly, the court found that, first of all, that the plaintiff was very credible because she admitted to a couple of affairs in the marriage, one intimate, one she declined to say was intimate. But anyway, found that she was very credible, and found that Mr. Mitchell lacked credibility, and gave 5 reasons for his lack of credibility. And I understand that the law is pretty clear that the trial court gets great deference with the ability to judge credibility, and only by clear and convincing evidence would error be assigned. But I do believe that the court did commit error in establishing that all disputed issues would be held in the favor of the plaintiff. So, in other words, the trial court said, I believe the plaintiff more than you, and therefore anything that's in dispute between the 2 of you, I'm going to fault and go with the plaintiff. In those areas, Your Honor, I believe first one is that my client, in his testimony before the court, repeatedly said that he really didn't want a divorce. He didn't want it from the start. He got served right around Christmas time, and he didn't want a divorce, but after mediation and what have you, he had resigned the fact that he was going to have to go through a divorce. Well, the court heard that testimony, and immediately after the hearing, the court issued her ruling, and said that I find that you're not credible because you said that you didn't want a divorce, but 20 days after you were served, you filed a counter complaint asking for a divorce. And the alternative pleadings, the Tennessee Rule 8.052 allows for alternative pleadings, and the Phelps case that's cited in my brief stands for the premise that alternative pleadings are not admissions and should not be held as penalties. But in this case, the trial court obviously held it as a penalty that he sought a counter complaint or filed a counter complaint for divorce, and then told her in the trial that he did not wish for a divorce. So that would put parties in a very awkward position. Now, the plaintiff was asking for alimony, so one of the defenses for alimony would be fault of the parties, of course. And so to establish fault of the parties, he filed a counter complaint alleging inappropriate marital conduct. So that would put the party in a very awkward position to either tell the truth at trial or hold back and try to defend one or the other, try to defend against an alimony claim. And I just don't believe that the law supports that. Secondly, the courts stated and found that my client said, "I wish I could ship you back." There was some testimony from the plaintiff that my client would get upset, and then the plaintiff testified that it was implied that my client would imply every now and then that he was going to ship her back to the Philippines if she didn't do such and such. Well, it was never in the proof that he said such words. It was only testimony by the wife that he implied it by his actions. And the court also said that this happened before the marriage, and she relied on that to cite my client's lack of credibility as well. My client said that he never said such a thing. He admitted that he might have said something in anger after the divorce was filed, but never admitted to saying such words. And so there's no evidence in the record that those words were uttered. Thirdly, the court found that he didn't think, that my client testified that he didn't think there were problems in the marriage, but then admitted that all marriages have problems and what have you. He did say that he didn't think that the problems of their marriage should result in divorce, but he did, and through his testimony multiple times, said that yes, there was problems, lack of sex. I think on cross-examination he admitted that the lack of intimacy was a problem of the marriage. He admitted that he had said some things to her in anger that might be a problem of the marriage. But he also said that he just did not think that the problems rose to the level of divorce.
He's actually contesting the divorce.
Excuse me?
Your client is actually contesting the divorce, is that?
No, Your Honor. He resigned to the fact for the divorce at the final hearing, but he never really wanted it. He just knew that it was ultimately going to happen, and so it took him more time than most, but he ultimately resigned to the fact that it was going to happen. But he was candid with the court in telling the court that he did not want it, that it was the plaintiff that actually wanted the divorce. And candidly, he would probably take her back today, but that's not in the record. But and then also, the court found that my client's testimony that he accepted the wife's appraisal for the real estate. The wife had the home appraised. My client accepted that amount. The wife testified at trial that she didn't think that appraisal was the proper amount of the value of the property because of some disrepair. Well, my client said that he thought that the disrepair to the house had been pre-existing. It had been there for 4 years plus, and he thought that the appraisal took that into consideration. So he basically just said, no, I don't think that the disrepair of the house had an effect on the value of the house. And the court held him and said that he lacked credibility because he failed to admit that fact. He did admit that there was disrepair. He just said that it had been pre-existing the appraisal. So with all of those errors that I would allege that the court made in attacking my client's credibility and just not taking his word at anything, the court made decisions on 5 important areas. They used the wife's value of the residence instead of the wife's appraisal. She deemed the Roth IRA, that we'll talk about in a moment, marital property. I'm running out of time. I need to move on faster. I'm sorry. But there's 4 issues, Your Honor. The first is the credibility issue. The second is the permanent parenting plan. My client was not maximized. The law says that you're supposed to maximize the parents' time with the children. The court did not do that. The court found no harm caused by either party. And in fact, the court had a finding that there's no proof that either parent is morally, physically, and mentally or emotionally unfit to parent. Yet, the court did not maximize my client's parenting time that could be exercised with the children. I'll try to save the rest of my argument for rebuttal. Thank you.
You have your rebuttal.
Good afternoon. May it please the court. I'm Randy Sellers from the Bradley County Bar. I represent the appellee in this case, Raquel Mitchell. First of all, before I state what the issues that have been raised are, I want to state what the issues are not. Grounds is not an issue before this court today. That's been mentioned. Alimony is not an issue before this court today. I heard that from counsel as far as apparent credibility issues with the testimony regarding incomes. Property division is not before this court today, except as it relates to the one IRA that Mr. Mitchell claimed was premarital, and I'll come back to that in a moment. What are the issues include, again, credibility, non-equal parenting plan, willful underemployment, and this IRA, was it marital or separate? Going into these a little bit, first of all, I want to say that as to credibility, and Mr. Miller has correctly stated the law, the appellate courts of this state are not to substitute their I guess, judgment in place of the trial court, who gets to see the witnesses face to face, sees their demeanor, hears how they speak, and that type of thing. One thing that was found is that my client, Ms. Mitchell, was not impeached at all. Her credibility was stellar. She, as lawyers will say sometimes, she was brutally honest. When asked why she had an affair on Mr. Mitchell by me in direct, she said, because I missed having sex. And that was her brutally honest statement. I thought she wanted attorney fees to be awarded. I asked her, would she like to have her attorney fees awarded? No, I would not. I will pay those on my own. So the court found her completely credible. Her answers were not consistent. On the other hand, you had Mr. Mitchell, who would say things, and Mr. Miller mentioned that some of these things where he quote, never really admitted something, but what he would do, he's the kind of witness that would say, well, I might have said that. Or he would say, if I did say that, it wasn't in front of the children. Or if I did say that, it wasn't in anger. So he would give these inconsistent answers and half answers when asked or called to task on certain issues. The credibility issue did weigh in, obviously, to the non-equal parenting plan. By the way, my client proposed a parenting plan that basically gave dad about 80 days a year, that type of thing. But I think the biggest issue we really need to look at in this case that the trial judge seized on is the unusual set of facts that Mr. Mitchell himself created. And so what I mean by that is, as it relates to credibility and as it relates to voluntary underemployment and as it relates to the parenting plan, 1 month after a divorce was filed, in January of 2020, Mr. Mitchell unilaterally cut his work hours from about 55 to 60 hours a week to 36 hours a week, unilaterally. The second thing he did was he changed his work schedule voluntarily. Interestingly, he changed it from third shift during the week to third shift during the weekends. Friday, Saturday, Sunday night. And interestingly, Chancellor Bryant seized on that point by saying, you've put yourself, sir, into a position where the weekends or when you're working, that's the best time to have your kids with you when they're not in school. So those kind of things that Mr. Mitchell created or was the author of himself. By the way, the parties were married in 2004, to answer the court's question earlier. They had 3 children. The divorce was filed in January of 20, as I said. Interestingly, these parties lived together throughout this entire divorce. And you may see in the record that it took us almost a half a year to get Mr. Mitchell out of the house after the divorce trial. And but that's not appealed by anyone. It's just one more fact of the unusual nature of this case. Well, so what were some inconsistencies that I believe are important? the facts are replete with those, and the chancellor I've recounted on pages 16 through 19 of my brief over and over and over all the inconsistent things that Mr. Mitchell stated that she found were inconsistencies that affect his credibility. Things such as him sleeping after work until 3:30 or 4 o'clock in the afternoon, yet he could take care of the children on weekdays. Not getting the children, in one instance, to school on time, or unable to pick the children up because he slept most of the day. Changing his own schedule, I've already alluded to. Dropping his income by almost one half. Losing a job because of sleep problems in the past. Oversleeping by his own admission, being a heavy sleeper. Statements like, when the kids are with me, they let me sleep until I wake up. So there he is at about 3:30 or 4 in the afternoon. On the weekdays, when he's not working, he said that he's a third shift kind of guy. He would stay up voluntarily till about 3 a.m. Those kind of things raise the eyebrow, I think, of the trial court. So, all in all, the court fashioned a plan. Really, she didn't see fit to give him the children on the weekends because Mr. Mitchell's working overnight, 7 p.m., 7 a.m., works an hour away, has to drive home, and then sleeps all day. So she fashioned something during the school year where Mr. Mitchell got Tuesday, Wednesday, and Thursday of each week in the afternoons, and then in the summer she makes up with them by having Tuesday, Wednesday, and Thursday overnight. And various holidays and the like. It's an unusual parenting plan, but it was brought on by an unusual set of circumstances. As to the court also fashioning this parenting plan, Chancellor Bryant was very careful and very thorough when you read this record in coming up with the best interest findings of the minor child, or children, excuse me. She went one by one through 36-6402, parentheses 3, that has all the factors, and gave a detailed explanation of her findings on each one of those. And one of the most important ones, as we know, is each party's employment schedule. My client, Ms. Mitchell, worked from 7:30 a.m. through 4:30 p.m. Monday through Thursday. That was consistent. Mr. Mitchell, as he sat in the courtroom, worked Friday night, Saturday night, and Sunday night, 7 p.m. to 7 a.m., and many Thursday nights, 7 a.m. to 7 p.m. And again, he had changed his schedule to a schedule of 55, 60 hours a week where he worked during the weekdays, again, overnight, to that weekend scenario I've mentioned. He had some unusual answers when asked about his income and the lowering of his income unilaterally. I asked him if it was fair that mom had to work a 40-hour week, yet you choose to drop your income by over half and do you believe that is fair? And of course he gave an answer like I said a while ago. Well, it's not really my place to say what's fair or not. So really wouldn't answer the question, but believed that it was okay for him to cut his historical 55 to 60 hours to this 36 hours a week, putting a further strain on my client to come up with other expense money as well, because that affects child support, as we know. Interestingly, on the issue of voluntary underemployment, there was an alimony award, and as you heard me say, that has not been raised on appeal. The court based his ability to pay on his former income of around $90,000 a year, not his cut down version that he fashioned after the divorce was filed. And by the way, there were no temporary hearings in this case that related to temporary support or the like. The parties were living together, and so bills were being paid along the way. But again, the court found that he had the ability to pay alimony based on $90,000 a year. He didn't appeal that, but he appealed voluntary underemployment as it relates to child support.
What puzzles me about this RRS that's involved here, Seems to me it would be very simple to determine when that thing was started.
The IRA?
IRA.
Yes, and that was my next issue, Your Honor, the last one, really. I've cited case law in my brief. The burden of proof, if you're claiming something as separate property, the burden is on the person claiming it, which would be Mr. Mitchell. And simply put, Mr. Mitchell did not produce the very thing that Your Honor just stated, and that is some kind of statement to show, here's where I had this on the date of marriage, and here's what it was worth then, and now we have a calculation now. The only proof that was introduced, as I've said in my brief on that point, was Ms. Mitchell, my client, finding a statement that was in like 2008 that showed it was in existence then. And that's all anyone had on that, on the IRA for historical reference. Again, burden of proof was not carried. There was no showing by Mr. Mitchell that he had a premarital interest in it. And I don't think the court really had a choice but to say that he did not carry that burden of proof. And I've, again, cited the case law that the burden is on the person claiming separate interest. So, in conclusion, I believe that based on the case law, this court, as I've already stated, is not to second guess the trial judge who sees the witnesses face to face, witnesses their demeanor, hears their answers to these questions, whether they're good, bad, or indifferent, and then comes away with this person is more credible than this person. And simply put, I believe she had a real issue, again, with some of the unusual behaviors of Mr. Mr. Mitchell in coming about to find that credibility was in serious question. So that is my presentation. If the court has any other questions, I'll be glad to answer them. Thank you very much.
Thank you very much, sir. You have your rebuttal.
Yes, Your Honor, and the court did find that my client, in the words of the court, voluntarily changed his employment and did so to avoid child support and alimony and was willfully underemployed. However, that was never an allegation made by the plaintiff. Not once did the plaintiff make the allegation that you're underemployed, that you did that on purpose to avoid child support or alimony. That came from the courts in thin air. Now, there were questions about, did you change your schedule? Are the hours of 55 hours a week now? No, they're 36, but most of the time they're 48 because he worked the Thursday 12-hour shift as well. So he was still full-time employed, but the court just said, I find that you did that on purpose to avoid child support and alimony, and there was just never an allegation or nothing in the record for the court to have made that jump, that's the reasoning behind him doing that. And on the IRA, my client could not find documents to support his position, but he was very definitive. He remembered where he went to open it up when he did it at First Tennessee Bank, 2003 tax year. They got married in 2004. He had it that time. He put no more money in it from the date of its inception. The plaintiff testified she never put any money in it. She didn't know when it came into existence, but my client was very definitive. So we thought that we carried the burden of proof by a preponderance of the evidence because he knew when it started, how it started, where it started, and that he rolled it over from First Tennessee to Edward Jones in 2009, which is the statement that the plaintiff had to present to the court. The plaintiff also testified that anytime they talked about the IRA, that my client told her that it was pre-existing of the marriage, so she had no proof otherwise in that regard. She basically just said, here it is. I don't know what it is or when it happened, but and then my client, I think, carried his burden of proof because he was so definitive in his answers and his testimony.
He did not produce any documentation as to the inception.
He did not have any. I asked him many times. He did not have any. He said he could not find any. I think he started it back in 2003, and he's just sort of forgotten about it other than rolling it over that one time, and he's just let it grow. He's not put any more money in it from its inception. And of course, no marital funds went into it from its inception, and there were no decisions made as far as changing the portfolio. It stayed Intel stock when it started. It's still Intel stock now. Now, the court granted that IRA to my client, but she did so at the expense of other marital property, that because she declared it marital property, the value and the offsets were such. So, and again, the plaintiff even testified, back on the issue of the underemployment, the plaintiff and the parenting plan, the plaintiff even testified that since the change in my client's schedule, that he's around more, that he's able to help me more, and she said it's been rather nice to have him around more and to help more. My client did that so he could be a more day-to-day parent and not a weekend parent. And what the court ended up doing to him is relegating him to neither, really, not a weekend parent nor a day-to-day parent. And the court certainly did not follow 36-6-106 and order a custody arrangement that permits both parents maximum participation possible in the life of the children, and therefore we feel like she erred in that regard as well. So with regard to the credibility issue, with regard to the IRA issue, with regard to the parenting plan issue, and the willful unemployment issue, we ask the court to reverse the trial court in those 4 areas. Thank you. I'll stand for any questions. Thank you for hearing me today.
Thank you very much.
Okay.
Your case now has been presented to this panel for resolution. The attorney should receive notification of our opinion within a reasonable period of time. Thank you very much for your presentation. The attorneys may be excused.